A couple people have asked me to talk a little bit more about qualifications in legal reasoning. So I am giving a little lesson on qualifications and backing in legal reasoning using the Toulmin model. I hope it will be helpful. In trying to prepare for this, I used a book called An Introduction to Reasoning by Toulmin, Richard Reek, and Alan Janik. And so throughout, I have my own examples, but I've also included some of the examples that they had in their book. So we all know about the basic Toulmin triad, where the basic model of reasoning is that there is some piece of information that leads to a conclusion or a claim. And how do we get from the piece of information to the conclusion or the claim? Well, there is a warrant, some kind of principle, value, idea, concept. It's another premise that you have to believe in order to make the conclusion or claim based on those data or grounds. And we see this in everyday reasoning all the time. We might have a data or grounds, the weather is beautiful, leading to the claim, so everybody wants to go outside. What's the warrant behind that? Basic principle, since when the weather is beautiful, everyone wants to go outside. Here's another example. This one draws from sort of a combination of scientific reasoning and the political environment. So from a piece of information, human activity like burning fossil fuels is leading to climate change. We can come up with a conclusion, so we must stop human activities like burning fossil fuels. And there's a lot of warrants because this is a pretty complex argument. And, but here are some of them. Since climate change is dangerous, and if human activity is dangerous, then we need to stop the activity. And if we can stop a danger to humanity, we should. And so these are a combination of scientific and political kinds of reasoning. This premise over here, this piece of information that I just was talking about, is itself an arguable proposition. And the scientific research that collects data has led to this claim. I've talked about the basic model of legal reasoning using Toulmin concepts when we are applying it to the situation where we're determining whether somebody has violated a particular statute or not, and which level of type of homicide should we talk about. So here's a basic model in first-degree murder. So the piece of information we start with is the defendant purposely caused the death of the victim, and that leads to the conclusion, so the defendant is guilty of first-degree murder. And what is the basis for that argument? How can we make the inferential leap from saying that he purposely caused the death of the victim, to that he's guilty of first-degree murder. Well, we have a warrant, which happens to be the law, which states that a person commits murder in the first degree if for the purpose of causing the death of another person, a person causes the death of another person. Again, this data grounds, these aren't necessarily facts. They're already a conclusion that has been developed from a lower level of facts that came to the interpretation of that the what that person did was done with a purpose. Here is an example from this book that I mentioned, Intro to Reasoning. And this is an example of how we make inferences based on testimony in a trial to a conclusion. And so we have person Z was seen on the night in question running down the street 1 block from the scene of the robbery just after it had taken place. So that's a piece of information. And so the prosecutor, presumably, is arguing the claim that person Z had the opportunity to commit this crime and is very possibly the guilty party. So you are making a conclusion based on this evidence. Now, what is it that allows you to make this, draw this conclusion? Well, in this case, it's a sort of general principle of human behavior. In normal circumstances, ordinary people do not run down the street after dark, but robbers fleeing the scene of a crime do. So this behavior can be taken as suspicious. You can see right now that there's an opportunity for rebuttal in this piece of legal reasoning, so that the defendant's counsel may introduce other evidence that provides a reason for this person to be running down the street at night. And so this would not necessarily warrant the conclusion that they were suspicious. Here's another example from the Toulmin book showing how you go from witness testimony to conclusion. And in this particular case, it's expert witness testimony. So the basic legal reasoning process that's going on in a trial, where you have lots and lots of witnesses brought to testify, is that witness Y says such and such. And so therefore, you're being asked to conclude that it is so. So witness Y says so, so therefore it is so. Obviously, that's going to depend on the credibility of the witness. So you're going to be getting witnesses from different sides of the argument. And one of the questions that you're going to have, let's say you're in a jury, is which of the pieces of witness testimony is more reliable than other pieces of witness testimony, if in fact it seems like they are contradicting each other. But the basic model of expert testimony is that witness Y says so, therefore it is so, because witness Y has the training and expertise required for a trustworthy judgment and is willing and able to act as a responsible expert witness. We can take this witness's word on this matter. And that's why in a trial, if you're going to call up an expert witness, you have to provide evidence that in fact they really are an expert so that you can in fact rely on the expertise. Added to that basic triad of data, claim, and warrant is the backing. And here's a basic template for an argument with backing there. That is, data, so claim, since warrant, which is supported by the backing. Toulmin says that generalizations are what's in the backing, that these generalizations make explicit the body of experience or knowledge relied on to establish the trustworthiness of the ways of arguing in any particular case. And so within the legal context, there are accepted forms of backing to establish the trustworthiness or credibility. One of the things that's really interesting, I think, is how different contexts for argument, sort of different fields of study, lead to different types of warrants, different types of backing, different types of qualifiers. So Toulmin says that in the legal context, warrants rely on deliberate collective human decisions. That is, the whole legal process is a deliberate collective human activity. And it has developed a whole structure with rules and documents and guidelines and everything. And we find our warrants and our backing in this collective body of human decisions. Scientific context, the warrants and backing may rely on a recognition of general patterns in the natural world. So if we have an understanding of cause and effect, that's kind of a general understanding of the physical world. You do something and it causes something else to happen. And so we develop that understanding, that kind of warrant, sometimes through our personal experiences, sometimes through experimental study in scientific contexts. So Toulmin defines the sort of question of what backing is in the legal context this way. Can we find proper support for this warrant in the common law statutes, administrative regulations, codes, and so on, currently accepted as valid, binding, and authoritative, or in force within the relevant jurisdiction? So this goes back to what I was saying about backing in the all these homicide arguments. So the warrant is in many situations as the actual rule that the law, the statute, but that statute doesn't tell us all that much sometimes. And so we need to go further into sort of the background of that statute and look for interpretations and other explanations. And so the whole human structure of American legal jurisprudence is where we find that. In the scientific context, he says the question is different. He says, can we find support for this way of arguing in currently accepted theories that rest on adequate experimental evidence or other observations and are in proper accord with our long established ideas about the general working of nature? So basically in the scientific context, there are sort of this long established ideas about the general working of nature. This is that all people could develop, but then other backing is in the scientific evidence, the experimental or observational evidence that has been collected and has been accepted as reliable and authoritative. So to go back to my examples, in the weather is beautiful argument, the backing of this argument, so everybody wants to go outside, is supported by past experiences that show that people generally want to go outside when it's good weather. And in my climate change example, the backing is, again, pretty complex because this is a complex argument. And there's both scientific and political kind of reasoning going on here. But part of it is the trust in the scientific consensus and the knowledge of the scientific experiments and observations that have led to the conclusion that burning fossil fuels leads to climate change, and understanding of the basic physical process of cause and effect, a trust in scientific ingenuity. So all of that is part of the backing that allows one to make the argument that we must stop human activities like burning fossil fuels based on the grounds human activity like burning fossil fuels is leading to climate change. And here is the illustration of the murder example. So the backing becomes which is supported in case law treatises, jury instructions that define and interpret, for example, the Arkansas jury instructions. A person states with purpose with respect to his conduct or a result thereof when it is his conscious object to engage in conduct of that nature or to cause such a result. So you see this definition of purpose is very, very helpful in trying to figure out whether or not somebody has in fact acted in a way that is purposeful. So the definition is, so a person acts with purpose when it is their conscious object to do something. So you have to see if the evidence shows that there's some kind of conscious act object that, and that's hard because we don't have on our forehead this thing that says, I have the conscious object to do X. And we are constantly making inferences based on the external evidence that we see. But again, all the case law and all these other things help us in making these interpretations. And then the definition further helps us by specifying two basic types of purpose. You can have the purpose, or two basic purposes. You can have the purpose to actually engage in the conduct. That is, you're throwing a rock and are you really, did you just decide to throw the rock, or did you just by mistake have a rock that flew up because you slid on a rocky path? So if you slid on a rocky path and a rock comes up and hits somebody in the head, you don't have the conscious object to engage in that conduct of throwing a rock, or even causing the result of a person being injured by the rock. In contrast, if you are playing a game of pseudo baseball with rocks, you may in fact have the conscious object of throwing the rock. On the other hand, you may not have the conscious object of causing the result of throwing a rock, i.e. of hurting somebody. So there are multiple things to be thinking about when you're trying to think about what purpose means. And all of the backing that's available helps you in interpreting it. Here's a good example from the book that shows the backing. On the first example, and this is about a case in which a hotel had plaster fall that hurt somebody. And the hotel is arguing the first side, which is that the plaster that fell was caused by the earthquake. So the grounds were that the plaster fell, and the claim was that the plaster fell because of the earthquake. The warrant was basically the idea that earthquakes can cause plaster to fall. And the backing for their argument was not just any old person, but to actually get a expert witness who was able to testify that that this warrant is probable or possible. So that's an example of backing. I also like this because this kind of gave you an example of rebuttal, because basically what you have here are the different arguments made by the two sides based on two different sets of grounds. So the hotel is arguing the plaster fell because of the earthquake, which occurred on June 13th. The alternate side is arguing that in fact the plaster fell because of negligence. And so they use, in order to rebut the argument that it was natural disaster versus negligence, they use a whole different set of facts. And their facts are that the city inspector cited the hotel for unsafe conditions, and that they and that the hotel actually contracted with a plasterer to come, and they were scheduled to come on June 15th, and, which is pretty important, that seismic and city monitors showed no other damage from the earthquake to any other building in the town. So that suggests that evidence suggests an alternate explanation for causing the plaster to fall. It is that the negligence of the hotel caused the plaster to fall. And so there's a warrant there that is that there was nothing about the building that made it any different from any other building in the area. And the only difference between this building and the others, which didn't have plaster falling, was the unsafe conditions. I've talked a little bit about stare decisis, and I thought this was an interesting graph to show this whole process of stare decisis, which we'll be looking at in the weeks after spring break. So stare decisis is the idea that when you have a new legal decision, you have to, you can't just disregard previous legal decisions. You need to consider previous legal decisions. And if the situation is the same, then you need to follow previous legal decisions. So this is a basic model for it. And the argument is that this case is like the precedent case, that is the case that was decided in previous legal decisions. This case is like it, 1, 2, and 3. And so the conclusion is, so the present case should be decided just like the precedent case. And what's the warrant in there is basically that The rule of law is applicable in both situations when you have similar situations. So this particular precedent case can be relied on as authoritative in deciding the present one. An important thing about this is that precedents must be within that jurisdiction. They are only binding if it is within the same jurisdiction. So if a decision in Arkansas happened, and there was a case in Arkansas and it happened, you are not bound by decisions in Ohio for the same kind of thing. You might take that as persuasive authority, but it's not going to be binding authority. So the warrant or the backing in of the whole stare decisis process is expressed up in here. In common law jurisdictions such as those of the US, the general procedure is to decide cases by reasoning from analogy, acknowledging that no two cases will be absolutely identical, but picking out and relying on critical relevant similarities between the facts of the case to be decided and those of the authoritative precedent case. So obviously the other side is going to argue that they're too dissimilar to rely on precedent. So that's basically what happens in legal argument on any kind of interpretive issue where you are comparing your set of facts to another set of facts and deciding whether or not they're similar enough to apply the same rule. This is called analogical reasoning, or the root of that is analogy. All right, so the last thing I want to talk about are qualifiers. And qualifiers indicate the strength and limitations of a claim. And here are a collection of verbs or adverbs that Toulmin gives for that you might be using in an argument. And the model has our same model, but basically we introduce a qualifier in when we go from the data to the claim. Back to our weather example, we could say the weather is beautiful, so everybody wants to go outside. To qualify it, we might say, so almost all, or most, or some, or, children. I mean, there's infinite ways to qualify it that restrict basically the strength of the claim. In everyday reasoning, it's often really a good idea to avoid totally broad generalizations like my first one. Everyone wants to go outside because some totally unqualified generalization is very easy to rebut. If you say everyone wants to go outside when the weather's nice, all you need is one single example to rebut that. And so it's usually a wise move in most arguments to provide some kind of qualification. And this kind of shows that you're reasonable. It shows it sort of establishes your ethos. It also makes your actual logic stronger because you're not disproved by one single case against it. In the scientific and political context, we see qualifiers all the time because nothing is really absolute in this region. So in my climate change example, a qualifier might be Human activity like burning fossil fuels is leading to climate change. So to the extent technically and politically feasible, we must stop human activities like burning fossil fuels. And we all know that the completely unqualified statement, we must stop this, sometimes turns people away, sometimes, and is sometimes completely impractical. So a qualifier might be to the extent that it's possible. As we've been looking at these murder cases, we see over and over that we start thinking about the qualifiers. And so we can argue that the defendant purposely caused the death of the victim, so the defendant is definitely guilty of first-degree murder. It's a pretty strong qualification, but we can also say that they're probably, or more likely than not, or certainly. We could even say unless and get into the defenses. The standards of proof kind of get at qualifications, and it's not necessary for you to know this for this class, but in some legal settings, like if you were going to convict somebody of capital murder, you want a very highly certain decision. So it's beyond all reasonable doubt. So it is just the slightest bit of qualification, well, maybe no qualification. On the other hand, if it's a less serious kind of situation, you may have a much more qualified sort of standard for determining guilt, which is more likely than not. More likely than not is definitely, you would never want to convict somebody of something that puts them in jail or puts them to death with beyond all reasonable, with just more likely than not, because you're just almost as likely to make an error the wrong way. And that's why we want our standards of levels of guilt, our standards of proof at different kinds of levels of qualification. Again, the context determines what might happen with qualifiers, just as it does with what might happen with warrants and backing. In scientific reasoning, all of it is pretty much based on this understanding of levels of probability. And especially if we're getting into research into human behavior, medicine, which is a human thing, physician can't ever say, this treatment definitely will work. A completely unqualified kind of claim. They can only, probably at the best, say there's a good possibility this treatment will work in this particular case. So all this good possibility, this treatment and will work in this particular case, those are all qualifiers to the claim that the treatment will work. And where do these qualifiers come from? Well, based on warrants and backing in the context. So the qualifiers in a legal context are usually of two different kinds. One is how good is the evidence? So how strong can you make an inference based on some piece of evidence? And then also, what limitations are there on the relevant legal provisions? So this gets at that issue of, say, stare decisis, that, what does the rule apply to? What does the statute say? The example that this book that I was reading gave regarding a legal context and a qualifier was an example of a person who dies intestate, meaning without a will. So you can make the claim that when George died without a will, the bulk of his estate is going to go to his wife, even though there's no will. You probably need to qualify that. And so they did with a not too hard qualification, but presumably the bulk of the estate will go to his widow. And because of a warrant, and the warrant is the normal rules of governing intestacy. However, whenever you're saying this at the original, you have to make sure that within the jurisdiction, that is in fact the case of the intestate rules, that in fact the wife, the widow, gets inherits the estate. And part of the reason why you have to qualify it is that you don't know for sure that there is nobody else out there making claims. So you need to provide some kind of evidence that you've done your best to find other claimants. This is why most jurisdictions have a 6-month or so waiting period, basically where you have to announce that so-and-so died, and where you try to get, let the public know that so-and-so died, and presumably if there are any claimants out there, they'll come and make their claim. It strikes me that the memos that you wrote had a lot of qualifications in them, because you're arguing just based on what you can see and what limited evidence that you have, this is what's likely or not to happen. And then in those memos, you could also say, well, it's possible they might do X, which may cause me to qualify my claim of what would happen. Toulmin points out that in a trial situation, the advocates are trying to advance their claims with as few qualifiers as possible. So once you get to the point where you are making an argument in a trial, you're going to try to avoid qualifying your claims. But of course, in the process of getting there, you may deal with lots of claims, qualifications. In a trial, the juries and judges, on the other hand, they're constantly dealing with the qualifications. So they're trying to weigh the strengths of the claims that are being offered in order to make the decision. So you could imagine a jury conversation where they say, well, no, it seems like more likely to be that based on what this piece of evidence. And appellate decisions also may be involved with qualifiers in claims, because they will often decide a ruling, but they will qualify its application. They'll say, this rule only applies in these narrow situations. You can't just apply it into other situations later on. So ultimately, within a trial situation, and these homicide cases that we've been looking at, we are interested in the strength of the evidence, the strength of the inference that we can make based on the evidence. And you are trying to come up with a claim that it will have will lead you to the least amount of qualifiers. So if you are making an argument, the defendant yells, "Kill him," therefore he has the purpose of causing the death of the other person. The question is, how strong is the inference that you're making? Can you then say, therefore, for sure, he is guilty of first-degree murder? Well, probably not, because the strength of the inference is pretty weak. Just because somebody says kill him does not mean they have the conscious intention or object to do something, to cause the result of something. And given the particular situation, this was the teenage jealousy case, if you try to make an argument for first-degree murder, you'd have to qualify that quite a lot. It would be probably a lot easier to do a much lower level where you wouldn't have to qualify it. Or in a case where the defendant is told by the police he shouldn't drive, and also by his passenger that she's scared. This was a drunk driving, one of the drunk driving cases. Can you make the inference from that, that therefore he has the purpose of causing the death, therefore he should be found guilty of first-degree murder? Again, it would have to be pretty qualified. You can't say, therefore, just based on that, has the purpose of causing the death, and you'd have to qualify that statement. And so you'd probably be able to come up with a better argument if you go further down the chain of level of mens rea. If the defendant brings a gun to the hospital and shoots his father 4 times, is that an unqualified example of causing the death of something, having the purpose of causing the death of something? Again, we're not completely sure, but it's certainly much less qualified than the 2 that preceded. When the defendant plays Russian poker with a loaded gun with the victim, is that the purpose of causing the death? How strong is an inference that you can make that he had the actual purpose, that is the object of the object of his intention, the conscious object of his intention was to do something or cause the result of something? So what I'm hoping you're seeing is that this continuum of types of homicide is kind of reflecting sort of a calibration of the qualifying kind of statements that you can make. So that what you want to do is identify the level of homicide that you can make with the fewest amount of qualifications, so that you can strongly state that it's definitely recklessly or definitely with the purpose of, as opposed to weakly stating that it may be with the purpose of, or it may be recklessly. And all this comes back to our understanding of, human behavior and what kind of thing motivates people, why do they do what they do? And again, it's necessary for us all to draw in all this kind of information, warrants and backing, because motivations and intentions are not obvious on the outside, and they're not writ across your forehead. And so we're constantly making inferences based on the witnesses and the testimony and the facts and the evidence, et cetera, as that we go. So I'm hoping that this was helpful to you. I've given you the specific citation. I'm going to be sharing the PowerPoint along with this recording, so you can definitely go back and look over it and think some more about it. I hope you find this interesting and helpful in thinking about legal reasoning.